in the name of Bola Tinubu shall be forfeited by the United States and disposed of according to law. The funds remaining in the account shall be released to K.O. Tinubu. The claimants, Bola A. Tinubu, K.O. Tinubu, individually and on behalf of Tinubu family, and Alaja Mogaji, hereby release and forever discharge the United States, its officers, agents, servants, and employees, its heirs, successors, or assign from any and all actions, causes of action, suit, proceedings, debts, dues, contracts, judgments, damages, claims, and or demand whatsoever in law or equity, which the claimants, their heirs, successor, or assign ever had, now have or may have in the future in connection with the investigation, seizure, detention, forfeiture, disposition, and release of the defendant property. The parties further agreed that this court will retain jurisdiction of this matter for the purposes of implementing this settlement agreement. The United States and the claimant agree to bear their own cost and attorney's fees. The United States and the claimant states that they have read this agreement and understand this agreement and that they intend to be bound by its terms. Agreed, Michael J. Shepard. This was that moment. The moment that Tinubu turned around and said the money they found, $1.6 million that they found in his 3 bank accounts, which was after the investigation into Edward Andrew narcotic trade and the rest of that, all right, where Tinubu is linked. So Tinubu just said, the money is not my money, it's my mama's money. Remember, all of this, so it was in Nigeria, it wasn't in America. All other members of his narcotic trade and all of that, they've been arrested. They were in jail. So he was able to give the FBI, the CIA, the DEA, all of these guys, he was able to give them all they needed. He was able to snitch on his own fellow drug dealers. Okay? And then they were like, you know what? In that case, you have to work for us. You have to begin to work for us. That's how he became their asset. And they said, you know, we are not going to say, oh, this money, the court will release the money. But it's going to now be under the IRS that, okay, you did not declare the money. Since you didn't declare the money, you have to forfeit $460,000 and you will take a 1.1 million or 1.1 million and $40,000. So his mama claimed to be the owner of the money, who was kind of giving him the money, sending the money to him in America. Okay. And he was saving the money and saving the money. Okay. And to those of you who probably will know, in the late 70s, in the late 60s, early 70s, late 70s, 80s, especially in the late 70s and in the entire 80s, right? Drug dealing in Isaleko, that Abibatu Mogaji herself was also fingered as one of those drug dealers. And they are not just drug dealers in like selling drugs to people. They are like international drug dealers. Tinubu himself was sent to America for this same purpose. So when they flooded the Chicago, Illinois, and all these surroundings with their white heroin and all that, right? They needed somebody to be in charge of the account, to be managing the account. Even though it was recorded that, he was working as a non-commissioned or non-official something with the mobile. And he was being paid $1,200 every month as his own salary. But in his bank account, 3 bank accounts that he opened, including the one his wife also opened, he had more than, the money that passed through that account was like more than $10 million. The last one they caught when they started, when they confiscated the accounts, the properties, there were also properties they took from them, right? So when they took all these things from them, in the bank account, they had a combined balance of $1.6 million. Or before they could arrest him, he was back in Nigeria. In fact, he was already running to be a senator in Nigeria. So rather than arrest him and extradite him back to America, that was where they made their deal. That was when they all agreed on this, that, okay, you know what, we'll let the case, you know, we can make your case disappear. So when somebody said, when someone actually said that, you know, Shay, do you have the evidence that Tinubu, sorry, the CIA, if they indeed accuse Tinubu, or did they confirm that Tinubu is their asset? I'll show you their court case on the 11th of November. Just wait too. I have, I think it's about 58 pages documents here to share with you. But let me put it on the screen again. So we have, hang on. I think it's this one. Okay, you know what? In order not to mix them up, I'm going to close some. Let's see. Right. So when FBI released the first set of those documents, right? Tinubu went back to court and said, no, they can't release any further documents. It will kind of like finish him totally. And he is right. In my own opinion, I think he's right to try to want to stop it. So let's go back to that. So on the 11th of November, Aaron Greenspan sued for another Freedom of Information Act, FOIA, to appeal the judgment of the district, the Northern District Court of Illinois, which said that Tinubu's privacy, Tinubu's privacy is more important than the public interest. So what that then mean was that, yes, Tinubu is the president of Nigeria. Well, he also kind of have the rights to privacy. So since Tinubu argued in Chicago that they should not release his documents, so the court agreed with him that, you know what, it's a two-way thing. You are a public figure now, and we don't know what this, like you said, that this releasing these documents will destroy you and can cause a lot of irreparable damages to the United States and even to Nigeria. And this is what we're going to do. We will redact these documents. Every document that the FBI will release with the name of Tinubu on it, they should remove his name. They should blank it. So last year, they released Tinubu's documents. Then it was after the election. It was after he has been sworn in. It was after the FBI visited him in Nigeria, the FBI director. So when they released that document, it was almost like useless. I think I shared that with you earlier. Maybe I should bring it up again. Okay, so it was a useless thing to read. It's not as straightforward as the one I just finished reading to you earlier now, right? It's not like that one. Let me see, 2023. I think it's this one. Just give me a sec, okay? Yeah, this is the one they now redacted. The one that is totally useless to read. Okay, let me see if I can get out. Yes, I can. Now, take a look. The former one, you were able to read his name, but in this one, they have removed all his name from it, including all the investigation of investigation of all his activities in Indiana police, in Chicago, in New York, in few other places, right? Where he was actually investigated, right? They removed that. They even removed what they investigated him for, FBI. Here you get now. they just blank the whole thing. It's so useless. You can't read it. See? It's so useless. This would have been all the information. Here you can look at this one. Department made available a plastic see-through bag containing white powdery substance. So the blank stated that this was represented to be a half ounce of cocaine and was obtained from dash blank blank blank. SA blank took possession of this bag containing the white powdery substance and placed it in an evidence sealable bag where it was in fact sealed tight. Investigation on blank blank at Maryville, Indiana, file number by SA blank blank, date dictated 6/13, that's the 13th of June, 1990, you know. See this one, Detective blank Marion, Indiana Police Department, blank 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 blank, see, blank, where you cannot see his name or anything, or other things that they believe could give us the idea of what they are talking about. Blank, 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 blank. See? Blank, blank, blank. All these places, they were supposed to be reported. Said it's provided the following information. What information? Blank, blank, blank. Investigation on date, blank at Maryville, Indiana, blank, blank, blank. See? Blank provided the following information. Blank, 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 blank. Nothing. See that? Detective blank Marion, blank, 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 see, blank. So this is the one that FBI released. And this is what prompted the Aaron Greenspan, Unveying's partners to now go ahead and appeal this judgment and say, this is useless. It's not useful. Nobody can use this. Nobody sees what is inside there. It's all like empty. Yeah? How can you even explain this to anybody? It's blank, 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 blank. It's useless. Can't read it. Right? Just to protect Tinubu. So that is when, on the 11th, their argument now is that, let's leave it. It's useless. You can't read it. That's the one, that's the one they released last year. Just because the court said Tinubu doesn't have privacy as president, but FBI should go ahead and release the document, but they should redact it. And they did. So without giving up, David and Aaron went back to appeal that decision. This time around, away from Chicago, straight to DC, Washington, DC, where the arguments of this time around, right, the FBI, the CIA, the DEA, they are compelled by under the law, okay, to honor the FOIA, request. But they also have their own thing, where they can tell you, for the sake of national security, they will exempt, like we are exempting this also person. We can't release these things because this person, we cannot, because the line of argument in law is that they will say they can neither confirm or deny. But you see where they gave Tinubu up is that they said, we cannot give information or record of an active asset. They did not kind of categorically say Tinubu is their asset, but they said they cannot honor the request of these people to release information on Tinubu because they cannot release information on an active asset. Then their line of argument is that we can either confirm or deny. Is Tinubu a CIA asset? We can neither confirm or deny. We can't confirm and we can't deny. What are you talking about? Okay, release all the, you've investigated him. There's evidence that you've investigated him way back. Can you release all the things you've investigated about him with the name Bola Ahmed Tinubu? We cannot. Because if we release information on an active agent, it will jeopardize what is the national security of America. Really? Now here is the argument in court in Washington, D.C., where the representative of the American CIA, FBI, DEA argues out that they cannot see FOIA requests and responses, FBI, DEA, CIA, and number two, the civil action. So the argument is that FBI and DEA have properly asserted global responses pursuant to privacy exemptions 6 and 7C. FBI, privacy interest outweighs the public interest in disclosure. DEA, privacy interest outweighs the public interest in disclosure. So the plaintiffs' privacy and public interest arguments are unpersuasive and contrary to law. CIA has properly asserted global responses pursuant to exemption 1 and 3. The exemption 1, exemption 3. Now, this is just the table of contents, okay? So here, you have, in fact, let me just go straight to the argument, okay? This is the argument of why they can't release Tinubu's record. They are not denying that Tinubu's record, they have Tinubu's record. And they are also not confirming that they have it. But they are there in their court to say, we can't release it. You get? We can't say we do have it, but we can't say we don't. So the defendants, FBI, Central Intelligence Agency, CIA, and the Drug Enforcement Administration, DEA, collectively defendants, by and through undersigned counsel, so they have their own lawyer there, respectfully submit this memorandum of points and authorities in support of their cross motion for summary judgment under Federal Rule of Civil Procedure, Rule 56, and in opposition to plaintiff's motion for summary judgment. So remember, this is a follow-up to what the district court attorney or district court judge in Illinois, in Chicago, Illinois, ruled that Tinubu's record should not be released. And if it's to be released, it must not. Let me see if I can even put this folder bigger on the screen. Yeah, it should be better this way. Let me see what it looks like on the screen. Yeah. And I don't want it to block anything. No. I don't want me to block anything, but don't worry. So take a look at this. This case arises from numerous Freedom of Information Act requests that plaintiff Aaron Greenspan submitted to the FBI, CIA, DEA, Executive Office for U.S. Attorneys, Department of State, and the Department of Treasury, Internal Revenue Service in 2022 and 2023. The request sought criminal investigative documents concerning third parties, Bola Ahmed Tinubu, Lee Andrew Edwards, Muiz Adegboyega Akonde, and Abiodun Agbele, who, according to plaintiff, participated in an international drug trafficking and money laundering ring with operations in Chicago, Illinois. The remaining the remaining disputes involved defendants' global responses to plaintiff's request for records about Tinubu, the president of Nigeria, and the DEA's glamour response to plaintiff's request for records about Agbele. So here, the plaintiff also sued the Executive Office for U.S. Attorneys, Department of State, and the Department of Treasury, Internal Revenue Service, but on August 13, 2024, he voluntarily dismissed those defendants. So the phrase global response originated from a FOIA case that sought information concerning a ship named the Hughes Global Explorer. And the CIA refused to confirm or deny its relationship with the global vessel because to do so will compromise the national security or divulge intelligence, sources, and methods. Do you get that now? So that is why it's called global response. So global response is named after a vessel, a ship, named Glomar Explorer, which is the bottom, so it's kind of the bottom difference in this argument, okay, where the CIA continue to say, we can neither deny or confirm. We can neither deny or confirm. Do you have information on Bola Tinubu? We can neither deny or confirm. What do you mean? Yes or no? We can either say yes or no. We cannot say yes and we cannot say no. Okay. So the FBI and the DEA properly asserted global responses under FOIA exemption 6 and 7C because the requests seek criminal investigative documents pertaining to third parties that, if they existed, would interfere with the third party's substantial privacy interest in not being associated with law enforcement investigative records. The CIA properly asserted global responses under the FOIA exemptions 1 and 3 because confirming or denying the existence or non-existence of records related to Tinubu will reveal classified information that is protected from disclosure by executive order and statute. To the extent that plaintiff attempts to argue that the existence of requested records have been officially acknowledged, such that a global response could not be used. This argument will not succeed for numerous reasons, not the least of which plaintiff never demonstrated that such an acknowledgement had ever been publicly and officially made by defendant. Of course they have. FBI already released documents of Tinubu's investigation. So they can no longer now turn around and say global response, global response. What do you mean global response? You have already given us, Abi. Have you not been listening to me? We have it here, the record of Tinubu released by the FBI in 2022. In 2024, FBI is now using global response. They are saying we can either confirm or deny. We can either confirm or deny. What are you talking about? You already confirmed, released some of these criminal records. Investigation, that's it. All this investigation you've done, you've released them. In 2023, you released a bunch of it, right? A bunch of it. And you redacted it. You blanked Tinubu's name out. How can you now in 2024 come out and say you cannot confirm or deny that Tinubu's record, you have Tinubu's record? You see, that is the argument 2 days ago. The court hasn't ruled yet. Shall you get now? It hasn't ruled. It's just their lawyer. That is the lawyer to the counsel to FBI, CIA, and the DEA, trying to say they can't confirm or deny. So therefore, for the sake of national security of America, they cannot confirm that they have the record of Tinubu. How can you turn around like that? So there are 3 central questions before the court. And the plaintiff's case fails at each step. This is their lawyer talking, don't forget to. First, whether an affidavit of an agent of the Department of Treasury, IRS, PSCs the global responses of the defendants who are not part of the Department of Treasury. That is, whether the affidavit of an IRS agent constitutes an official acknowledgement of the FBI, DEA, and CIA that the records requested by plaintiff exist. Under circuit precedent, the answer is no. Second, whether a complaint brought by United States Attorney's Office of the Northern District of Illinois seeking forfeiture of seized funds in Tinubu's bank account based on the IRS agent's affidavit transform the affidavit into an official and documented public disclosure confirming the FBI, DEA, and CIA records requested by the plaintiff exist. The answer to that question is also no. This is their lawyer saying the already made public document doesn't exist again? The answer is no. Do you have the document on what the supposed IRS agent that investigated the proceeds of narcotic heroin trafficking and all that? Do you have the record? Do they exist? The answer is no. What? We still have that on our screen. If you roll back this video, you will see all the FBI documents that were released in 2022, 2023. Now in 2024, they said they don't exist. The lawyer is saying the answer is